On the slopes of Diamond Head, this is Kapiolani Community College. Kulia ika nu'u, strive for the highest.
Aloha. Welcome to BLAW200. I'm Ben Carroll. Last time we took a look at contracts. We started a major area in business law, and we're going to continue today with interpreting contracts and some of the defenses to contracts. So we'll continue merrily on our way. But as always, we'll first start out with a review of what we covered last time. Make sure we're getting that embedded in our memory banks. Okay, so what is a contract and what are the requirements of a valid contract? So various definitions of contract, but essentially what we're talking about is an enforceable agreement, so promises that the court will enforce. And what are the elements we need to have a valid and enforceable contract? First of all, we need an offer and an acceptance, and there's various ways that this is talked about, meeting of the minds, offer and acceptance. And this is just the agreement part of it. So some formulations actually say that the first element is agreement, but it's probably better to look at assent and offer and acceptance, because when we say agreement, that's generally how we think of the entire contract is the agreement. Okay, the second one is going to be consideration. So this is the exchange of value. Third one is going to be capacity. So this is the ability to understand that you're in a contract. And then the fourth one is legality. So we're not going to be able to enforce something that's illegal. And you recall we had a couple of other things we looked at that some people considered defenses, some people considered elements. And again, we'll be talking about those more today. Okay, so what is the mirror image rule in contracts? And what do we mean when we refer to a meeting of the minds? Okay, well, the mirror image simply means that the offer and the acceptance need to be exactly the same. So when somebody makes an offer, I will do this for $100. If the other side says, okay, but I'd rather have 80, that's not a mirror image. So that's not, the acceptance is not accepting exactly what the offer put forward. So that doesn't meet the mirror image rule. Now again, let's not get hung up on mirror, because mirror actually reflects opposite, but what we mean is that we have the offer and the acceptance are the same. And recall we said that when we get to sales, there may be some different rules when we're talking about more experienced people like merchants. But certainly in common law, we need to have the offer and the acceptance being exactly the same for a contract to form. Now, meeting of the minds we'll talk a little bit more about today, and this refers to whether or not we have genuine assent or genuine agreement as to what the subject matter and the conditions of the contract are. So what we're talking about is whether or not we're using terms the same, whether mistakes involved, whether there are other things that may keep us from actually having that connection, that meeting of the minds. What are some valid forms of consideration in a contract, and what would not constitute consideration? So you recall when we're talking about consideration, we are talking about value, an exchange of value. And in many contracts, it's fairly obvious. So when we're making a purchase, one side is offering money, the other side is offering goods or services. So in that case, it's clear what the consideration is. But recall that there are other forms of consideration. So as long as value is being exchanged, that can constitute consideration for a contract. So we talked about giving up a right. So if I give up the right to sue someone, or if I give up the right to do anything else that's legal, my giving up that right or that detriment to me can constitute consideration. So we used examples like the rich uncle that offered money if you would not do certain actions, smoking, drinking, whatever. And that actually can constitute consideration because we are giving up a right if we have a legal right to do those things, and we, in essence, sell our right to do that. So that's the consideration. Recall there's some other instances where there's a pre-existing duty. In other words, if we have a contract to trim the trees and we've paid for it, and then the tree trimmer comes back and says, okay, I haven't done it, but I will do it if you pay me extra, if you pay me more, that would not be valid consideration because the person already has a duty to do that. They've already been paid, so they're not giving us anything new. So there's no consideration there. Again, maybe some different rules when we get with merchants, and we'll talk about those in a few sessions. How about if a firefighter offers to put out the fire in your home for money? Again, pre-existing duty, already has a duty to do that, so they're not giving us anything new. They're not giving us any value. Okay, so those are the things that wouldn't be consideration. Okay. What is capacity to enter into a contract? And can minors enter into a contract the same as adults? Okay, you recall that capacity is a legal term, and the close term that we are more familiar with used in medicine is competency. So we're talking about the ability of a person to understand that they're entering into a contract and what the consequences of entering into the contract are. And so I refer to the areas as infancy, incompetency, and intoxication, because I like to have those 3 I's so that I can remember them. A lot of folks will refer to infancy as minority. Same thing. We're talking about not being of legal age, not being of the age of majority. So those are 3 areas that become involved in whether or not a person has the capacity to enter into a contract. Now, age for minors is obviously arbitrary, and it's changed over the years, 18 for some things, 21 for others. Various states have had different ages. Personally, I actually became of age to drink 4 different times. So Washington, D.C. was 18, Kentucky was 19, years ago Hawaii was 20, and lots of places were 21. So is anything magic happening then? No. The law has decided that. And the law also determines other ages at which it says things happen. But we use the age of majority, and that's standard across most of the country, is 18. So what happens if a minor enters into a contract? Well, they can enter into a contract. So that's fine. The problem for the people contracting with a minor is that the minors can disaffirm and can get out of a contract. Okay? So that means that that contract is voidable. One of the parties can get out of the contract. And so minors can enter into contracts, but most contracts a minor enters into, the minor can get out while they're a minor and even a reasonable period of time after they reach majority. So most people are not going to want to enter into contracts with minors when the minor can get out. Okay? That's what we mean by voidable, is that one of the parties can avoid obligations under the contract. And we did talk about some exceptions for necessities and things like that. Okay, so voidable contract we just talked about. A void contract is a contract that simply has no force and effect. So, for example, an illegal contract. And which applies to incompetent persons? Well, generally, all of our capacity issues, for the most part, are going to involve voidable contracts. So, if we said a minor can, simply because they're a minor, void a contract. When we talk about incompetent persons, the court will look and see whether or not that person understood what they were getting into. So they will look at the mental ability to understand that they're entering into a contract and what the consequences are. And if they find the person did not understand due to competency, then they can avoid that contract. Okay? Same with intoxication. So if a person's intoxicated, they would need to prove that they did not understand what they were getting into and that they were signing a contract and what the consequences were. So that would be a proof issue, and those are voidable, meaning that the court may allow them out of the contract if the proof is sufficient to establish that they did not enter into the contract. Now, what happens if someone has already been adjudicated? In other words, they've already been determined not to be competent to contract and do other things. So, for example, someone has had a guardian appointed for them. They are now a ward. They are not able to handle these affairs. Well, in that case, the court wouldn't need to, on this particular contract, go and look at that again. Why? Because it's already been determined. So, whereas normally in a voidable contract, the court would determine whether or not there's sufficient capacity there. In an instance where there's already been a court determination, they wouldn't need to do it again. So that's a void contract. That contract has no effect. Okay, what are some contracts that are illegal? And what else makes a contract unenforceable? Okay, we think of an illegal contract as something that's against the law. So there's certain statutes that have indicated what you can contract to do and not to do. So, for example, usury is charging excessive interest. That's not legal. Gambling in most states, many states, is not legal. So if you have a contract for those, that's not going to be enforceable. Okay? I think we talked about contract to sell illegal drugs, obviously not going to be enforceable. So what other kinds of things could make a contract unenforceable rather than straight legality? Well, the court may look at certain provisions and the effect of the contract, and it can determine that a contract is unconscionable. In other words, that a contract is so unfair that it's not going to enforce it. So it can refuse to enforce either the entire contract or part of the contract. And we'll talk more about remedies in our next session. But the court can look at those provisions and say, we're not going to enforce this because of our inherent power, equity power. We're not going to give force to that. And we talked also about, for example, exculpatory clauses where somebody tries to change their legal duties, and often the court will not allow that. Okay, so we're going to proceed merrily on and look at some of the little deeper into interpretation and applying contract law. So let's take a look at our agenda. We're going to look at the formal requirements. So you recall we had touched on these. There's some contracts that need to be in writing, that sort of thing. And we'll talk about the statute of frauds, which addresses that. We'll talk about parole evidence. That's another word for oral evidence, and that has to do with what the court will allow in to explain written contracts. And then we'll talk about the genuineness of assent. So in one sense, this goes back to whether or not there's been a meeting of the minds, whether or not a contract has been entered into. And we'll look at such things as mistake, fraud, misrepresentation, duress, undue influence. And then finally, we'll look at how courts interpret contracts, what they look at, how they fill in the blanks, that sort of thing. Okay, so you recall when we talked about the elements of contract, last session we spent considerable time on the offer, acceptance, consideration, capacity, and legality. And today we're going to look at the required form, and we're going to look at genuine assent. And again, those are frequently considered to be the defenses to a contract, or rather than elements. Doesn't really matter as long as you understand that we need to look at these as well. Okay, so what are the formal requirements? Well, they are going to enforce contracts as long as they're clear and as long as all the elements are there, whether it's in writing or not, unless there are specific reasons that it needs to be in writing. So unless the law or the agreement of the parties indicates something needs to be in writing, then it can be oral, and that will be equally as enforceable. Now, obviously there are some problems with oral contracts, and a lot of those have to do with proof issues. So if you are in an oral contract, and if it's anything at all complicated, you can have misunderstandings, there can be unclearness, and so in a lot of instances it's just not a very good idea, because if you need to enforce it, you frequently end up with a situation where you say have he said, she said, and it becomes a credibility issue. So just common sense will tell you a lot of contracts you're going to want to put in writing, even if an oral contract is satisfactory. Other instances, if you're dealing with people that you know and you find a trustworthy situation, well, maybe a handshake kind of contract will work for you. But again, certain kinds of contracts do need to be in writing. We call the contracts that have specific requirements formal contracts, and of course everything else we would refer to as informal contracts. And formal contracts are considered to be contracts under seal, what we call recognizance, negotiable instruments, and letters of credit. Okay, so we'll talk about each of these briefly. I'll just mention that recognizances are contracts that have been reviewed by the court or are in front of the court. Letters of credit are frequently used internationally, but both negotiable instruments and letters of credit we'll talk about more when we're talking about the UCC. So an entire section of the Uniform Commercial Code will tell us about negotiable instruments, and there are requirements that to be negotiable, in other words, to be transferable, that it needs to be in writing. And we'll talk about that in a couple of sessions. But let's take a look at contracts under seal. Now, for many, many years, this was very important, and contracts under seal actually developed years and years ago. Many people were illiterate, and so they were not able to read their contracts. Someone was assisting them, and the seal gave that some authentication, so it indicated that it had been looked at, etc. So we still use seals in other regards, but the seal in terms of contract law, at least in the United States, is becoming much, much less important. Okay, now what was the point of having the seal? Well, in jurisdictions where the seal and in times when the seal was recognized, it meant that the contract was valid without consideration. So this was an exception to the rule of consideration. So if a contract was under seal, then it was considered to be valid and the court would not look behind it. Okay. Another thing that happened, and this is still present in several states, a contract under seal generally will have a longer statute of limitations. So you recall that the statute of limitations is the period within which we can bring a lawsuit on a contract. And in Hawaii, that's a 6-year period. But in states that have contracts under seal are still recognized, that could be extended to 8 or 10 years. So it would give you a longer period of time to bring an action on that contract. So the purpose of the seal is quite similar, actually, to what we use with notary publics and the corporate seal as well. So it's a manner of authenticating what we have. And so you will see frequently all sorts of documents that we have where we still use seals. And you're familiar, this appears on a lot of official documents, and it may be the gold foil seal that's been stamped. It may be various other types of seals. So it may simply be an embossed seal. Nowadays, it's actually, sometimes they actually print something and it says seal rather than appears to be seal. But again, this is something that is used, still used with notary publics, and the corporations still use this as well. So if you take a look, you can see some of the past uses we'll just briefly look at. You can see on the top is what we consider to be an old style seal. And this is from centuries ago. This is where we used to drip wax. You may have seen this, drip wax, and then you have either a signet ring or you have a stamp that makes an impression there. And you might frequently also have ribbons underneath, so it can look quite fancy. This is similar to what happens now in many Asian countries where we have what we call a chop. And so people, which is a symbol, and people will use that mark, that logo, so to speak, as their signature on documents. And so that's quite similar to this wax impression we used to have. So you can see on one side we have the embossed, where we simply press that into the paper. Obviously, when we do that, if we photocopied or Xeroxed it in some sense, it would not have that raised area. So that would be some protection that that's an official document. But more and more you'll see the notaries are using simply a print like we have on the other side. So it's simply an ink stamp. And so that's happening with the notaries. So we still use seals with the notaries. You will still have official documents that they want certified or sealed in some way. But in terms of contracts, that's really vanished from a lot of the states. Okay. In fact, the UCC does not make any distinction when we look at that in a few sessions between contracts under seal or not, and neither does the state of Hawaii. Okay, so another type of formal contract is a contract that comes under the statute of frauds. And again, this is a statute that is from England many, many years ago, and for the most part has been superseded in England. But still, a lot of it is in both our common law, and most states have passed statutes that enact statute of frauds. Okay, the rationale, there's two reasons that we have this. One is we try and apply this to what we consider to be important types of contracts, and the idea is that if we require a writing, then that will mean that people pay a little more attention to it. They appreciate the fact that it is an important document, and so it's kind of cautionary. In other words, it's to try and assist people in putting down what they need to have down. Okay. Second purpose is evidentiary. So if we do have a problem, as we indicated earlier, if it's in writing and the writing is sufficient, then we will have an easier time proving what went on, who agreed to do what. And so for both of those reasons, kind of a prospective reason in making sure people do get this all figured out, and then after the fact, if there is a problem and we have to go to court, then we have a writing to evidence what went on. Okay. Now, there's a lot of exceptions to this, and we'll look at those in a minute. I should indicate that the writing here does not need to be an entire nice-looking contractual writing. So it really just needs to be something that indicates or evidences that the agreement met the standards of definiteness we've talked about. So you recall what we talked about that needed to be definite in a contract for us to actually feel like that we had an agreement and that we're talking about the same thing. So recall that had to be the identity of the parties. We need to at least know that. We need to know the subject matter, clear about what it is the contract deals with. We need to know the consideration or the price. So we need to know what's being exchanged. And finally, we need to know when it's going to be performed. So if we have any kind of writing or even a couple of writings, if we collectively have notations that will show that those things are definite, that would be sufficient writing under the statute of frauds. So we're not looking at a nice, clean, complete, comprehensive contract necessarily, but we do at least need those elements written down in writing to meet the requirements. Okay, so again, evidenced in writing. So you may sometimes see where it says it needs to be in writing, but that really implies more completeness than's required. So we really talk about evidenced in writing. And what sort of things do we need to have in writing? Well, a contract to transfer interest in real property. Okay, so obviously Hawaii and many other places, certainly in Old England, your property was your major asset. We want to be sure that people that are dealing with their property have some evidence of this in writing. So you're not going to find an oral mortgage, so don't bother looking. Okay, a contract that cannot be performed within 1 year. And we're talking about it cannot be, not that it isn't. Okay, so if you agree, I will work for a period of time or I will not compete with you for a period of time, if that's more than a year, then that would need to be in writing. Okay? Interestingly, if we talk about lifetime, is that more than 1 year or not? Well, we don't know. Crossing the street may make it shorter than a year, so lifetime doesn't necessarily need to be in writing. It's something that needs to inherent in the contract or the specified time period. If it's more than a year, needs to be in writing. Okay, contract to pay the debts of another needs to be in writing. Contract made in contemplation of marriage. Okay, so many of us are not probably going to be involved within that, but if you are in fact rich and famous, then perhaps you will be involved in what we call a prenuptial agreement. Now, this would also apply to dowries, but it's been a while since I was involved in a dowry. How about you? But anyway, contemplation of marriage. And then finally, a contract for the sale of goods greater than $500. Okay, now, that doesn't seem like much these days. And in actuality, the Uniform Commercial Code has suggested and recommended that this be up to $5,000 to mean we're dealing with something fairly substantial. Even our small claims court goes up to $5,000. So it is recommended that this increase, but many states still, including Hawaii, still have the $500 limit. Okay, this brings us to parole evidence. And as I suggested earlier, parole evidence is another word for oral evidence. So we're talking about testimony in court and when we can do that. And what the parole evidence rule suggests to us is that if we have a written contract, the court does not want to allow oral testimony to change that, to contradict that. So if we, for example, have a contract and it says $1,000 due on a certain date in writing, and we later attempted to say what we actually meant was less than that, we just put that in for purposes of the writing, but we meant something different, the court's not going to allow a contradiction of a writing by oral testimony. And if you think about it, makes common sense. Otherwise, writing would never mean anything if we could always try and explain it away. Okay, so very clearly, if you're trying to contradict something in writing with oral testimony, you fall clearly within the parole evidence rule. On the other hand, if there's something that's ambiguous, almost everybody will allow testimony to come in to explain something that's in the contract, but we're not clear what it means. But the question is, and the courts seem to go a little bit both ways on whether you can supplement. In other words, whether you can add something orally. It doesn't contradict, but it's not really explaining something there in the contract. So kind of midway in between. So let's take a look and see if we can get a handle on this. So we have what we call a promissory note. Again, we'll be talking about that down the road, but essentially it's a promise to pay. And here we have, I owe you the sum of $160, which I shall pay on demand to you. Okay, so what do you think? Can we allow oral evidence in here to explain who the I is and who the you is? Okay, and there is actually a case in point on this, but we are allowed to use parole evidence to explain something that's in the writing. And so here we clearly have an I and a you in the writing, and we would be able to use parole evidence, in other words, oral testimony, to establish who I and you are. This comes up actually more often than you would think. If, for example, somebody signs a contract and then they get married or they change their name or something else happens, perhaps they've used a nickname, that sort of thing. So it's not uncommon to need to explain, okay, this was my signature and sometimes I use my middle name or Junior and this time I didn't. So this is more common than you would think. Okay, so these are the parole evidence exceptions. So we will allow parole evidence, oral evidence, to identify parties, to interpret existing items, and to resolve ambiguity. Okay. If we need to explain that we don't think a contract has actually occurred, or we should be allowed to get out of the contract because of some of the assent problems that we'll talk about, in other words, fraud, duress, misrepresentation, we will be allowed to present evidence of that. Okay. If we are entitled to equitable relief because we didn't understand we were getting into, or we were an innocent party, then we might be allowed to present oral evidence of that. And we can use oral evidence to show if there's a subsequent agreement or a collateral agreement to the written agreement. So what do we mean by subsequent? Well, some things may have happened after, and so we agreed to change things. And if we can contract orally for those changes, and this is happening after the writing, the court will allow that. What would collateral be? Might be you agreed to paint the house, also agreed to paint the garage. Might you have two different agreements for that? Sure. So you might be able to present oral testimony as to that. Again, here we're not so much contradicting anything, and we're not using prior or contemporaneous testimony about what existed then. This is subsequent to. Okay, now genuineness of assent, again, this goes back to whether or not there is actually a meeting of the minds. And so this will get us back in one sense to whether or not we've actually had an agreement. But we deal with it because this is a defense that needs to be brought up when someone's trying to enforce the contract. So the things that might interfere with genuine assent would be mistake. Mistake can be on behalf of both parties, or it could be on a single party. Fraud and misrepresentation, duress, and undue influence. So we'll take a look at each of these and see how they and why they allow us to perhaps rescind or get out of the contract. Okay, so a mistake occurs when somebody has an erroneous belief about subject matter, value, or some other basic attribute of the contract. And we may handle different mistakes differently. So there's both unilateral or mutual. Again, unilateral being a mistake on the behalf of one party, and mutual being that both parties have mistaken something. Okay, so a unilateral mistake usually doesn't affect enforceability. So the fact that one party has made a mistake is not going to allow them to get out of the contract. Okay, unless there are some exceptions here. So if the other side knew or should have known of the mistake, so in essence is taking advantage of someone in that sense, then the court may allow a rescission of contract. If it's a clerical or mathematical error that slipped into the contract and it's not a gross negligence kind of mistake, then the court may allow that. And the court always has the power to not to rescind a contract or not enforce a contract if it thinks there's some inherent unfairness and it's unconscionable, and they simply on their own decide not to enforce. Okay, on the other hand, mutual mistake as to the subject matter will generally excuse. And so if the people think that they are contracting about something and in fact they're not, then there may be mutual mistake, and the court may say that they never really had a meeting of the minds. So there was a famous example where there's a ship. Turns out there's two ships with the exact same name, and the parties are agreeing to ship something, cotton, I believe, on the ship Peerless. Unfortunately, there are two ships with the exact same name. They sail at different times. One is going to reach the place and time, one isn't. So it is a mutual mistake. So in fact, they did not have a contract because they were not talking about the same thing. Okay. Now, this does not apply to value. Okay, so in general, the court's not going to look at whether or not you're making a good deal. Okay, There may be some exceptions, particularly as was indicated earlier, if one side is taking advantage of the other side. But in general, if you people attach different values to something and one is mistaken, and even if both are mistaken about certain things with the value is not critical to the contract as subject matter is. Okay. So again, when we're talking about consideration, the court looks to see that there's an exchange, but the court doesn't judge the how good the contract is or how much the value that's being attached is realistic or not. Okay. Now we get to misrepresentation, and you will recall this very similar when we were talking about intentional tort. So we did talk about misrepresentation, and so this will come back, and we'll revisit this now in contracts. So misrepresentation is a false statement that persuades somebody to enter into a contract. And if that's the case, then the innocent party can get out of a contract. Okay. Now, should say up front that this is something we'll need to prove, and the proof, this is an instance where the proof is higher than our usual standard of proof in a civil case. So if you hearken back when we first talked about the difference in burden of proof between civil and criminal cases, you'll recall that criminal case is very high, beyond a reasonable doubt, and we were talking about preponderance of the evidence, which is more likely than not, kind of a 50% plus rule. Now, clear and convincing is kind of in between the preponderance of evidence and the beyond a reasonable doubt. So we have clear and convincing, and we need to show that for fraud. So it is a higher standard to prove this. Okay, so to prove it, again, we need to show that the person made a representation of material fact, and you recall material fact is a fact important to making our decision. So it's a fact that if we knew it, it would change how or whether we enter into the contract or the terms or something. So it's a critical fact in our decision-making process. The wrongdoer, the person intended to deceive the innocent party. The party that received the misrepresentation relied on it. In other words, they did use it to make their decision, and they were in fact injured in this detrimental reliance, this reliance to their detriment, to their harm on the factual representation of the other side. So, give you a quick example of how this might happen. We have a case where someone was waiting for the telephone company to come and take out an ad in the yellow pages. They had been contacted earlier, and then someone shows up and says, "I'm here to take your telephone ad." So the person says, "Fine." They take out the yellow pages, they mark it up, they decide what the ad should look like, and the person leaves, and we'll talk more about this online, but the business owner did not get a copy of anything, not even sure who they were dealing with, but thinks everything's fine until a week later when the actual telephone company comes and says, "We're here to take your ad." So they're wondering, who the heck did I deal with? Okay. Later on, they get a proof, in other words, a preliminary copy of their ad, and immediately they write back and say, "I didn't know it was you. I thought you were from the telephone company, not this private company. I don't want the ad." And the private company said, "Look at the contract you signed." No way to get out of it. So eventually they actually sued the business owner, and in trial court it was determined there was a contract. He signed the contract and was liable to pay for this ad. And when it went up to the Supreme Court, they said, actually, it's clear from the record that the other side knew that this person was mistaken as to who they were. It was a mistake of identity, and that they had actually taken advantage and pretended, in essence, to be the telephone company. And so this was clear and convincing evidence of material misrepresentation, and so they let this person out of the contract. Okay, but again, high standard of proof, and so should have read the contract, should know who they're dealing with. We'll talk about some of this again online. Okay, so what are the different types of misrepresentation? Okay, we have fraud in the inception and fraud in the inducement. You sometimes refer to this as fraud in the execution, but this has to do with whether or not the misrepresentations cause somebody to enter into a contract or to take certain steps. And in this case, you can get out of the contract generally, and you can receive damages. And again, we'll talk about damages next session. Okay, fraud by the concealment simply means that you have concealed something, and that can constitute fraud too. So you don't need to affirmatively act to make a misrepresentation. So what would be an example of that? That might be if you were selling a house and you had dry rot or some kind of problem in the house and you painted over it. So you're affirmatively making something appear other than it is. So that could constitute misrepresentation. Okay. Generally, silence is not going to be misrepresentation, but it could be misrepresentation if you know that somebody has a mistaken view of something, or you've caused them to do that, and by silence you're implying that something is true. Okay. So again, all of these, you can, if you prove these misrepresentation, then you can rescind the contract, you can get out of the contract, and you can receive damages. Okay. How about a misrepresentation of law? Generally not. So a misrepresentation of law is where somebody tells you this is how it works, etc. And people talking about the law, you don't take that at face value. Okay. An exception would be if one person has knowledge of the law. So if an attorney is telling somebody this, then that might constitute. But just two folks talking to each other and telling each other what the law is, you should not take that as reliable, so you should not rely on that. Okay? And then finally, innocent misrepresentation means that you have misrepresented something, but there is no intent to defraud someone. And in that case, generally you can get out of the contract, the innocent party can get out of the contract, but they wouldn't get damages because it's an innocent misrepresentation. Okay, duress is another reason to get out of a contract, and duress essentially is whether somebody's forced into making a contract, and the force can either be a physical threat, it can be a physical force, or it can be economic duress. And so this is considered to be not voluntary because somebody has caused you to get into it, and you, in essence, you were forced to get into it. So what might be an example? Well, if you take your automobile or a computer or whatever to a repair shop and you go to pick it up and they won't give it to you until you pay extra, in other words, they kind of hijack you or extort you, then your agreement to pay the extra is not really enforceable. Okay, so because they have used duress, if you needed your car or your computer, you didn't have any options to take them to court because you need it right now, that would constitute duress probably. Okay, another problem area is undue influence. So this is where someone influences another person to enter into a contract or to enter into certain terms, and it's undue influence because the person has a confidential or fiduciary relationship with the other person. So this frequently comes into play when someone is dependent on someone else. So we often see this with aged and infirm people that have someone helping them, and that person becomes indispensable, so to speak, with them and can exercise undue influence over them. So they can, because of a physical, mental, emotional, or some other kind of weakness, they are able to influence them to take steps that they normally wouldn't. And again, it can be a threat to withdraw care. It can be other types of things of that nature. But the court may let the innocent party out and make that contract voidable if they feel that there has been undue influence. Okay, so contract interpretation. Well, this is the kind of the bottom line on what the court's going to look at to see, do we have a contract and how effective the contract is. So in general, courts will take a very liberal approach to interpreting contracts, and if they feel that the parties intended to enter into a contract, then they will assist in making that contract work. So there's kind of freedom of contract. You can enter into any contract that isn't illegal, and we will try and help you make it work. Okay, to the extent possible, we're going to use reasonable, effective, and lawful meaning of the words. So remember we talked about what words mean even when we were looking at statutes, but the court will use kind of plain language unless there's some reason to use other terms. Okay, the court's going to consider the proof and existence of the contract and possible defenses. Then it's going to see if all the terms are there, if there are any missing terms or vague terms, and then looking at parole evidence if we need to add some terms, and the idea of integration. In other words, for integration, we sometimes call that merger and sometimes call that zipper. So you will hear reference sometimes to a merger clause or a zipper clause, and that's a clause that says this is the entire contract. It embodies everything. And again, that's the idea of integrating and having our writing cover everything so that we know this is what the terms are. And then the court has some rules of interpretation they will apply to contracts to determine the priority of terms, etc. Okay, so some of the rules that the court's going to use is we're going to give normal meaning to words, obvious and common sense, unless we have some reason to do otherwise or the contract gives definitions or something. We're going to look at the contract at the time it was formed. So things that happen subsequently may come into play for other reasons, but we're not going to use that as interpretation. We interpret it as of the time it was formed. Okay. The court will try and give effect to the intent and the purpose of the parties. So again, we are looking to have the intent of the parties, and so we will look at what they meant to do. And again, this is kind of an objective intent. We don't look so much at subjective when we're interpreting. Okay, the court will construe or interpret. Construe or construction of a contract is another word for interpretation. So the court's going to construe the contract as a whole. So they're going to see that it all fits together. And again, this returns us to the idea of an integrated contract. Okay, specific terms will prevail over general. So the more specific we are, that will take precedence over if we have some general provisions. So again, they'll look at how the provisions fit together and again, try and make it all fit together. Again, once they determine that you intended the contract and there are no defenses, they will try and make it work with you. Handwritten terms are going to take precedence over typed, and typed are going to take precedence over pre-printed. So the idea here is that indication that these terms have been negotiated is going to be important. So if it's handwritten, we know somebody had to handwrite it, and if it's typed, somebody had to type it, whereas the pre-printed stuff is in the bottom of the contract. So a lot of this is what we talk about as being the small print. So there may be provisions that have been stuck in by someone else. And you've probably seen this happen where somebody will hand you a contract and you'll see all the small print and they'll say, oh, you don't need to read that. That's standard stuff. You know, it's in all the contracts, etc. And of course, that's your first red flag. Better read it carefully. We call that boilerplate. And again, boilerplate because it's just there. It kind of buttresses the whole contract. But those will be enforced, but the court is going to be more concerned with areas where it's fill in the blank or where there are interlineations or where it's very clear that the parties have in fact negotiated and agreed on these provisions. So the court will look at whether or not they think that the people have talked about these terms, and the ones that have been negotiated will take precedence. And finally, the drafter of the agreement, and that's the person that hands you the pre-printed form, any ambiguities, any unclearness that we find in that contract is going to be construed against the person that drafted it. So if you think about it, it makes sense that the person who came up with it is the one that's going to have the problem. If we don't understand what it is, the person who drafted it should be the one that takes the heat. So if somebody gives you a contract and it's pre-printed and you fill in the blanks and sign, and later on there comes a question what something means, you're in a better position than the person who put the ambiguity in the contract, so to speak. Okay, so where are we at? Well, the main thing that the court's going to do in looking at contracts is try and give effect to the intention of the parties. So they're going to look at what the parties intended to do. They're going to look at the terms. And if they feel that a contract was formed, they're going to try and give that validity and enforce that. And again, they will look at whether there are defenses, whether or not there was a problem with assent, that sort of thing. And if so, then they may allow rescission. They may allow you to get out of the contract. And again, we will talk about performance and breach next time around. Okay, the court's going to hold parties to certain standards. So again, we talked about the definiteness, and this is in the common law. And the reasons that we had the definiteness is both so that the court encourages people to do good contracts. So they want certain things to be in writing. They want you to do this well the first time, but also in the proof issues. So it's both the guidelines have some utility in assisting or causing people to do a good contracting job in the beginning, as well as using it when we do need to interpret and there are questions about enforcement. Okay, and then the court retains the power to use equity in ensuring fairness, ensuring that there was actually mutual assent and that sort of thing. And again, we will be looking at that more in the future. So I do want you to take a look at the LALIMA website. So take a look at the materials there. We've been covering large areas, and you may have questions about misrepresentation. You may have questions about the various defenses. Awful lot of material there, and we will be doing some exercises. So get a little better, more practical feel of how these things apply. Okay, so as I said, next time we'll be looking at performance. We'll be looking at what the remedies are with contracts, and we'll pretty much wrap up our view of contracts. So I will see you next time. This has been Carol saying aloha from BLAW200.